The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and evening, everybody, and welcome to the Australasian Timber Flooring Association 4th technical webinar of the year, which is on legal contracts and common misconceptions. My name is Joshua Fielding, and I'm the Membership and Events Manager with the ATFA, and I'll be your host for tonight. Today we have ATFA lawyer Ping Gangur from Level Playing Field Lawyers presenting for the webinar very shortly. So today's webinar, Legal Contracts and Common Misconceptions, is enthusiastically and proudly sponsored by Berger Siedler. Berger Siedler from Germany is the market leader in floor finish, adhesives and penetrating oil systems. Since 1926, Berger Siedler have been an innovator in these technologies and continue to set market standards by offering perfectly matched, cost-efficient solutions to the trade professional that highlight sustainability, safety and premium product performance. So please contact them here in Australia by sales@berger-siedler.com.au or by telephone on 1800 337 477 or on their website berger-siedler.com.au. So thank you to today's sponsor. Just before we get underway, guys, just want to talk about some up and coming events we've got with the ATFA over the next 6 weeks. Firstly, to our Tasmanian members listening, we've got the Hobart Trade Night commencing on the 1st of August down at the Greek Hall in North Hobart between 5 and 8 p.m. So anyone in Tassie who's around on that Tuesday, the 1st of August in Hobart, it'd be great to pop in and see you guys because it's been 3 years since we've had our last trade night in Hobart. So I'm looking forward to getting back to where I was born and bred in my hometown for that trade night. Then, guys, we're heading to the Gold Coast on Friday, the 11th of August. We've got the biggest expo in Australasia happening at the Star Casino between 11 a.m. and 5 p.m. We've got 6 demonstrations happening throughout the day. We've got free food, free drinks, and free giveaways. And we've got Daniel Boone from American Sanders coming out from the US to do a presentation on the perfect finish. So we've got plenty of tickets still available, and it is a free event for anyone who likes to come along. And that's at the Star on Friday, the 11th of August. Followed by on Saturday, the 12th of August, we've got the ladies of the ATFA breakfast at the Star with the ATFA gala dinner happening that night at the Star Casino. We still have some tickets available for the dinner. It's a fantastic night if you haven't been to the ATFA Gala Awards, so I recommend purchasing your ticket and having a weekend over on the Gold Coast on the 11th and 12th of August. Then, guys, at the 29th of August, we're commencing our next online workshop, which will be on sanding and coating existing engineered floors. And this will be running between 9 a.m. and 12 midday Australian Eastern Standard Time. Registrations are now open on the ATFA website. To find out about any of the events I've just spoken about, guys, please check out our website, atfa.com.au, or you can send me an email at josh@atfa.com.au. Okay, everyone seems ready to go, guys. If you have any questions for Ping during this webinar, please just type them into your text box and we'll come back at the end of the webinar, and it could be a legal question that you're going through at the moment or part of today's webinar. So I'll pass you over to Ping. Hello, Ping, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, I've got you loud and clear. So the floor's all yours. Thanks, Ping.
Oh, great. So my name is Ping. I'm the director and founder of Level Playing Field Lawyers. I've had a fairly unconventional career for a lawyer. My family started developing residential townhouse projects, and my sister and I decided to become residential builders, and we've been registered for the past 12 years. And after building, my family also decided to start a structural steel business, and that's when all the fun began. We realized how many issues subcontractors have with contracts and with non-payment. And so my husband and I started this law firm to help subcontractors negotiate their contracts, understand their contracts, and also to help them pursue payment when a dispute arises. And so we do a lot of these presentations because we get in disputes and we help people out of their problems, and some of them can be resolved quite easily, but a lot of them can be quite stressful, quite painful. And it all comes back to, I wish we could go back in time and try to change the contracts that we agreed to. So here we are today. We're going to talk about contracts and talk about some misconceptions in relation to contracts. Sorry, that's just the front cover. So during this session, we obviously can't cover everything in contracts. So we'll talk about the purpose of contracts, what are the types of contracts that flooring contractors have to deal with, the essential elements of contracts, I guess some food for thought in relation to negotiating your contracts or your terms and conditions, some common misconceptions, and then we'll go through some contract admin and contract administration tips, and hopefully answer some questions at the end of the session. So, broadly speaking, what is the real purpose of your contract? Obviously, most subcontractors that I talk to, they submit their quote in and they want to know they've got a job, so they want to get that contract as soon as possible to know that it's locked in, they have that contract. However, it's much more than that. Your contract is really your communication document. It should clarify how you intend to charge, so exactly how it's going to work, in relation to if there's more square meters or if they want to upgrade the product, how are you going to charge? Then hopefully it will cover off all the risks and responsibilities of the parties, and then there will be a payment mechanism, as well as if they breach the contract and don't pay you, for example. So when we're talking about contracts, we're thinking that we want the contract to contain everything that we're concerned about. And so when we talk to subcontractors, what we're thinking is, what are all the issues you've had in the past? What are some things that you're concerned about? And you want to make sure that it all gets inserted into your contract. The ideal position, obviously, is you have your own terms and conditions, which I know that it's very appealing, but don't take someone else's terms and conditions. They might not suit you. You can always start with a template terms and conditions and then amend it to suit the way that your business trades. So you want your contract to be complete. You want it to go through all the scenarios that you might encounter, so that there's some kind of certainty if that situation arises. And what are the disputes always about? It's always something to do with the cost, the scope, the quality, or the time. So you want to think about these issues in this specific project or your specific company. How does your contract need to reflect the way that you trade? And that's what it really is. It should be reflecting the way that you trade. So I'll give you some examples of disputes that arise. Timber flooring subcontractors have a lot of disputes about the color that they chose, the wood grain. So there's a lot in terms of the design. There are a lot of issues with the substrate. If you're relying on a client or a builder to prepare the substrate, and then it isn't suitable, there's going to be a quality implication. There's going to be a cost implication. So before you even start looking at your contract, your first point is to have a look at what are the commercial issues that you have with your business, and then does the contract reflect that? So what are the different contracts? And I'll get to the point afterwards about how people say, oh, we don't have a contract. If there is any commercial arrangement that you have with another party, it's quite likely that a contract does exist. And so various contracts that could exist would be your contract with a flooring installer, your contract with a flooring supplier or manufacturer. So these are all downstream type contracts. And then other contracts that you have are upstream, so with a head contractor or a client, or directly with a client. And you need to think about all the contracts that are going to exist on the project, because if you're engaging an installer, then you need to make sure that any obligations that you take on flow through to the flooring installer, by way of example. If you run a very simple business where you do just supply and install flooring products, where you're dealing with mostly homeowners, then our recommendation is to have terms and conditions which you draft that are drafted by a lawyer for your company, and that really consults with the way that you trade, and then start using it with your clients. And if you get feedback where people won't sign it, then you can always see how you might need to amend it. But if you're trading on your own terms and conditions, then it should be the best position for you. So other scenarios are like when the builder is giving you a contract. So the people in this room or in this webinar who contract with a head contractor and are presented with a subcontract for a fixed price lump sum contract. Those types are the riskiest types of contracts, because you're being presented with the terms and conditions of a builder instead of your own terms and conditions. So you need to think about all the different contracts that might exist in the environment where you're trading. And so I think when you think about contracts, one of the common misconceptions is, what is the contract? When did the contract form? People sometimes think it's when you start some work or when you get a signed contract, but when is it really? And legally, the position is, in order for a contract to have formed, you need offer, acceptance, consideration, and intention to create legal relations and certainty. But what does that practically mean? So I'll give you some examples that we've come across where people ask us, has a contract formed? The most common example would be, so you, as a subcontractor, you have your quote template, and on the back of the quote template, there's some terms and conditions, or maybe there's not even terms and conditions. Either way, you've got on your quote, you've got an offer where it will supply 100 square meters of this, supply and install this timber flooring for this price, and you give it off to a homeowner. So that's an offer. And if the homeowner, whether they sign or not, if they direct you to start on site or they pay a deposit, that is acceptance, and it's implied by the conduct of them either paying you or doing something in relation to your quote, which is really a contract. So in that scenario, I would consider that a contract had been formed the minute they pay the deposit or the minute that they direct you to go on site, because there's an acceptance, there's an intention to create legal relations and to accept your quote. And then we get this other scenario where you, as a subcontractor, you give the builder a quote, and then he gives you his purchase order or a subcontract, and you don't sign it, and then you just start on site. And a lot of our clients say to us, well, there's no contract. I didn't sign their contract, so I'm fine. You know, it's just, the contract's just my quote. However, what's happened is, as a subcontractor, you've given an offer. They've given you the subcontract template or agreement, which is the counter offer. So we will accept your price, but on these terms and conditions. And then you've accepted, it's either implied by conduct, by starting on site, or it's express. So a lot of these subcontract agreements will actually say you are deemed to have accepted this this contract or the terms and conditions in this contract by undertaking any works under the contract. So there are all these different points in time when your contract may have actually formed. Another case study, and I'm saying a concreter in this case, but there's actually a lot of clients that we've had that have that have this scenario, which is they get given a subcontract template, and it's got a drawing register, and let's say it says tender issue drawing 1, or it could be construction issue drawing 1, whatever it is, and then you check the contract, you might negotiate a few things, maybe cross out a few things in the scope of works, and then the builder gives you a new contract with another drawing register, and you don't check the drawing register because you just assume that it would be the same one as in the first contract. So you go ahead and sign. You go ahead and sign. And so contractually, you are bound by that new drawing register, even though they kind of snuck it in and didn't really alert you to the fact that there's a new drawing register. And maybe that new drawing register has, finishes, or it requires you to do things that you hadn't allowed for. But now that the drawing register is in that second version of the contract and you signed it, you probably can't get a variation. And there may be claims outside the contract, for example, misleading and deceptive conduct, but the simplest claim is under the contract. And under the contract, you need to check what you sign. If you get a contract and then you get a second version of contract, you need to check that they're the same. You can check it. There's programs such as Word Compare that will take PDFs and compare the documents, or you can just manually check the differences. But all these different points in time can substantially change your legal rights. So negotiating and tender review interviews and what to look out for. So at the start, I spoke about my view in terms of how we see contracts. It's that you should start by having a look at your business and think about the commercial risks, the issues that you have when you trade. And then you start with a tender review checklist. And I'll talk about the considerations that I would think would go into a tender review checklist. And so you start by first negotiating these points. Before you even get to the contract, before you even look at the words, it's what are the risks that I have or have not allowed for? And don't make any assumptions. A lot of the scope of works that we see, they have an all-inclusive wording. Supply and install all works in relation to this project, including but not limited to, and they'll give examples. And so you have to assume that anything in relation to your scope of works could be deemed included. So what you do is you create a list of exclusions. So when you create a tender review checklist, you think about what are the issues that I'm trading, when I'm trading, and you think about what are the issues in the scope of works, and you create a list. So what happens when you, what are some of the issues that we've come across in disputes and that you might want to think about? I think for everyone that's doing on-site building, site conditions are always an issue. So some of the site conditions that you might have to deal with would be the conditions of the substrate, the quality of the substrate, whether there's moisture, whether it's level, and then maybe dimensions. Perhaps with your quote, you've relied on a bill of quantities, or you've relied on the dimensions in the drawings, but then when you go on site, it differs from what you've allowed for. So also access, you might have assumed that you will be the only subcontractor on site doing, so say in a certain section, maybe level 1, you'll have free run to do your flooring, and there's not going to be other trades. It will obviously escalate your costs if it stop, and you've got other trades in your way. So if these things are going to affect you quite substantially, it's going to cost you a lot more, then you need to build something in to specify that you've based your price on certain site conditions. The next thing is staging and duration. And we'll go into this more with cost escalation. But everyone knows if you've got a job that's broken up into multiple stages and then they further break it down into stages, it's definitely going to cost you money. Either you're going to have to mob or demob, or you're just going to get little bits of work done here and there, and it's not going to be good for cash flow. And then in relation to the duration, if the project goes on for a year or it gets delayed, it goes on for 2 years, you need to know what types of protection you're building in to avoid further costs that you might have to incur. Now, and we'll go into that. I think we've got a slide on cost escalation, so we can discuss that more, because that's obviously been a bigger and bigger issue. The next one is design obligations. If there is a fit for purpose clause or there's something that pushes, actually with, as a subcontractor, you're assumed to be the expert in your field. And so if you install timber flooring that's not suited for a certain area and you should have known, then there could be issues and you might be liable to pay for the cost to rectify. So you want to have a very specific process for how you avoid design obligations. Who's doing the design? Who's selecting the product? Who's saying that this is the right product to use for that area? If it's someone else, great, put it in the contract and then you won't have the design obligations. Otherwise, you should insert something to try to avoid some of the design obligations. Existing structure. So there's issues with, and this will probably happen for renovation jobs, insurance jobs. You have to deal with existing structure, and there's always an element of uncertainty. So in your scope of works, in your price, have you excluded any works to the existing structure? Have you allowed for latent issues? So for example, if the existing structure isn't what you thought it would be, so when there's some partial demolition or whatever it is, so then you can do your works, is it what you anticipated? And then you might have some clauses around samples and tolerances. So you might want to expressly put something in to say how samples can deviate from the products actually installed, or it might be that we'll only supply X amount of samples or whatever it might be in relation to that. So it's really about how each business trades and what they price in and what they allow for. And then tolerance. Obviously, you have the Australian standards, so you have tolerances on what constitutes a defect. But some contracts might have an even smaller tolerance than the building standards. So you have to have a look and see if you can negotiate those kinds of things. And then who has responsibility for damage or defects? So who's responsible? Once you finish laying the timber flooring and it's all perfect, who's going to be responsible when you walk off if the construction continues? Are you supposed to put protection? Were you supposed to hand it over? What can you do to reduce your responsibility for damage and defects? Okay, so moving on to a case study. So just to illustrate some of these issues that can happen, we acted for a vinyl flooring contractor, and they were engaged by, it was a Coles job. So they're on very tight timeframes. They had to, the builder organised for a labour hire company to move all the food shelves. And I think this was probably at midnight, and they would do a night shift where they would remove the vinyl flooring and they would install the vinyl flooring. And so they were working under very, very tight time frames. When they got out there, there were some issues with moisture. They had to install moisture barriers. So there was the original sequence that the builder had planned and which the vinyl flooring contractor had agreed to ended up changing. So they, instead of going in a sequential manner, they had to do, we opened up this section quickly, demolish and replace the vinyl over here. We've opened up this section, go do this. And what it ended up being was that the vinyl flooring was slightly out of bond. It was still within tolerance, but it wasn't acceptable to the principal. And they ended up demolishing and redoing a bunch of vinyl flooring. And the cost ended up being, I think, roughly $200,000, which they backcharged the vinyl flooring contractor for. And so with the sequencing, it wasn't put into the contract. It wasn't identified that if you fail to follow this sequence, the vinyl flooring can be slightly out of bond, although within tolerance it will be slightly out of bond. So these are and I'm talking about an example where there's, I guess, greater project risk than some other jobs. And that's what it really comes down to. The amount that you need to amend a contract or the amount that you need to negotiate a contract comes down to how risky is a project. If a project is very risky, then you need to think about all the clauses that you need to build in to protect your company. If you're dealing with the same type of project that you've done hundreds of times using the same flooring product that you've always used, so you know how it performs, and you're preparing, so you've been given the obligation to prepare the flooring, and you'll be paid whatever is required to get the flooring to a standard that you can be satisfied with, then there's a lot less risk than when they're trying to save money and they're taking and the builder's taking all these things from you, for example, substrate preparation. But you can see that what they're doing it's just not very good building. There are issues with the way that they're scheduling things. There's issues with the way that they're not protecting the surfaces. There's issues with the way that they're allowing the substrate to be cured or whatever it is that you're worried about. Those things should all be alarm bells. Well, we need to think about what we need to build in. Another example is in relation to latent conditions on a renovation project. And what happened was, this was not a timber flooring contractor, it was actually a structural steel fabricator who was doing a renovation project. So it was, I think it was an apartment building that needed to be, half of the building was going to be demolished, and then they were going to build it up from where they demolished. And the latent conditions were substantial, and they had to go back to redesign, and that could cause substantial delay. And what happened was, by the time the builder was ready to go, the subcontractor had already picked up all this other work and did not have sufficient resources to proceed as per the construction program. So when you're talking about projects that have risk, such as latent conditions, or they may be delayed for substantial periods of time, then you look at trying to negotiate clauses into your contract to protect you. So let's have a look at a construction contract. Most of you, probably the first time you picked up a full construction contract, a full subcontract, and you looked at a 50-page document, you thought, where do I start with all of this? What does all of this mean? And what do I really need to be across? Am I going to have to sit here and read 50 pages and try to work out what that means for my project? And so I'm here to kind of break down the different parts of a construction contract. So the first part, and this is when you get one of those standard subcontracts. Not if you get a purchase order, it could be a version of this in small writing, and then you have your terms and conditions, which would be similar to the general conditions. So the front page of the contract, the first few pages, is the formal instrument of agreement. That's merely saying A, B, C builder engages this subcontractor. It doesn't really have too much in it. And the general conditions of contract would be similar to your terms and conditions. So if you're in a position to trade with your terms and conditions, you obviously, that's the best position to be in. To always try to trade within your, based on your terms and conditions. And then obviously have an understanding of what's in your terms and conditions. And then your quote is similar to a subcontract particular sheet. It goes through the name of the project. It goes through the subcontract sum. It talks about payment terms, talks about when you'll issue a payment claim. So it's a summary document that's specific to your contract and that specific project. Special conditions is if you're dealing with the bigger contracts, then you're drafting in special conditions. Special conditions are amendments to your contract. So they're, instead of a certain sentence in there, for example, if it says the subcontractor warrants that the product is fit for purpose, that the timber flooring is suitable for the purpose that it's going to be installed for, you could put in the special conditions and say, strike that out. We're not giving any guarantees for fitness for purpose. Some architect has chosen this timber flooring and we're merely sourcing it and installing it. We don't know if it's suitable. We're just being told to do it. And that's what special conditions is for. When someone presents you with a contract, but you want to change some parts of it. And then you have all the other things like the construction program and the drawing register and the deed of release. So in essence, all construction contracts are, they cover off the same sorts of things. That some might not be as complete, some might look smaller. You see some of those purchase orders and you think, oh, well, this is good. It's only 5 pages. But then you realize they've just used size 5 Arial, something micro, and it's really the same thing. They cover off the same issues. And you can't necessarily judge the risks in a construction contract based on how long it is, because the fact that all the issues are spelled out is not necessarily a bad thing. It's about what are your risks and what are your responsibilities. And I think the starting point is to look at the scope of works and not just cross out the things that that might appear in the scope of works that you haven't allowed for, but to proactively think about what the builder might have thought you would allow for, but you didn't allow for. So then you specifically write, excluded this. Or there might be some limitation. Maybe you've allowed for 100 square meters of flooring, but if there's more than 100 square meters of flooring, then you want to charge an extra cost. Or you might say that you've allowed to level the concrete, but only if it's within, plus or minus 6 millimeters over whatever. So wherever you should think about it, as the person that you're contracting with may assume that you've allowed for everything. So then if you proactively tell them, I haven't allowed for all these things, even if you assume they know, you're less likely to have a dispute, because you can say to them, hey, it's in the contract. We haven't allowed for this, so it's pretty clear. And then obviously it's also legally enforceable if you expressly write it, but it's a good way to communicate and avoid dispute. And that's what you do with the scope of works, because I think a lot of times subcontractors, they do these really great quotes where you really spent the time to think about what you're actually supplying and all the things that you aren't supplying, and then they get given a scope of works from a builder, and suddenly it has all these things put back in, and then you're thinking, but I had them removed off the quote. However, a lot of subcontracts, they have entire agreement clauses, and an entire agreement clause says that the contract is the entire agreement between the parties, and all quotes, other discussions are all superseded. So all you're left with is what is in a specific contract. So we'll go on to contract administration. And some of these presentations that we go around and give to subcontractors is about encouraging a conversation about your contracts, a conversation about what's in there, what needs to change, what are other people in the industry negotiating, because maybe I could negotiate this, and instead of taking on this risk or taking on this responsibility, I don't need to do that. People get very caught up with pricing. How much are you quoting for that job? What are you getting per square meter for supply? What are you getting per square meter for supply and install? And your terms and conditions in your contract, can drastically change what will be recoverable, because it's not what you charge, it's what you get paid. And your contract, that communication document, is really going to affect what you get paid. And maybe for a certain job, you might never look at the contract. It may never be brought up. It may never be brought up, and you simply get paid for the subcontract sum. You finish it, there's no dispute, and you just get paid for it. But the thing about risk is it's like gambling. It's gambling. It's gambling. It's the amount of times that you have to sign a contract where it's not weighted in your favor. The number of times that you do that until you hit a dispute or you hit an issue. Because if it's a risk and it's something that is an issue with your trading, if it's something that your company hasn't allowed for, it's something that you're not managing, it's just a matter of time. There will be some issue with it. So you need to be aware of, in your contract, what are the risks that you will have issues with. And if you're aware of those risks, your first step is you try to negotiate it. But you might get to a point where you try to negotiate it and you don't really get anywhere. So what else can you do? You still want to sign the contract. It's really profitable. So hopefully you've got a margin. You either avoid the risk, you price the risk, or you manage the risk. And that's what this slide is about, managing the risk. So say you've got a contract and you really want to do the project. It's really good for your profile. There is some margin for the risk, but if all these risks that you're taking on, they all hit you, it's not going to be a profitable contract. So then you look at how do I manage the risk? And that's why we say you know, in the construction industry, I always hear this saying, oh, the builder's taking the contract out of the bottom drawer, or he's throwing the contract at me. But the contract should never be in the bottom drawer. It should be, you should have a checklist. You should know what's in your contract. As you're working through the contract, you should be administering the contract. You should be complying with the contract. So it shouldn't be coming out of the bottom drawer. It should already be on your desk. And you know, you don't want to look through that 50-page document every single day or every month when you issue an invoice. You don't want to pull out that 50-page document and read it from back to front. You don't want to do that. No one has time for that. You want to have a checklist, and you want to have, in this contract, my scope of works is this. I've allowed to do all the leveling. I've allowed to do all this stuff. And what can you do to manage all the risks in the contract? So I'll give you a simple example. Variations. Variations is one of the biggest areas for dispute. Because it's the head contractor has allowed for a certain price, and then now you're asking for more. It's something that hasn't been allowed for, so there's always a little bit of an argument about it. In your contract, in some of the in most subcontracts, there are time bars. Variations must be issued within 5 business days of a direction to vary. So let's think of an example of you're a flooring contractor and you excluded any moisture barrier or any substrate prep, and then you've been directed by the builder to go and do the leveling and the substrate prep. So you think, well, that's a variation, and hopefully within 5 business days you send a quote, and then ideally before you start, you get some written confirmation of acceptance of the variation, and then you proceed. So you have a look at what is required in your contract to comply with, to get a valid variation, and then you comply with it. If the project is likely to have a lot of variations and the wording has strict time bars, then you manage it. You manage it by getting approval before you start the work. It's obviously not always possible. Sometimes you're just doing day works and you didn't know there was going to be an issue. You didn't know there was going to be access issues. And so variation accrued before you were able to notify. But you just be aware, if that's the contract that you have, well, this is how you administer it. I don't think a lot of flooring contractors have liquidated damages in their contracts, but subcontractors, a lot of subcontractors do, so I'll just cover it off briefly. If you have liquidated damages in your contract, then you need to comply by issuing an extension of time notice. And I'll go through some misconceptions about liquidated damages in a moment. But you read through your contract. There aren't a million things to do in your contract, but in terms of contract administration, there certainly is compliance requirements. There are compliance requirements for variations, for extension of time, in relation to payment claims, and then if there are any allegations of breach, you have obligations in relation to responding. And with quality, there might be a quality control process. So you need to make sure that you are complying with the contract, not just what you think is suitable for putting someone on notice of variations. If the contract says there's a specific process, then you follow the specific process. So I think it's the starting point. If you talk about what is the most crucial, and I understand that negotiating contracts and contract administration, it's all a cost-benefit analysis. It can be quite costly to pay a lawyer to do a contract review, or it can be quite costly to get a lawyer to draft the terms and conditions, or whatever it is. So if you're starting at what is the most crucial in terms of the impact, it would be the scope. So it's a clear review of the scope, clearly ensuring that your scope does match your quote. And then after that, you're looking at what you can negotiate in. I'd probably still say variations and site conditions are more important than time management on the contract. But if you have a contract that has liquidated damages and it's a high quantum with no cap, then definitely liquidated damages is something that is a big concern. But generally, I think there's more disputes about variations in site conditions and defects than there are about time. And then if you have retention, I know a lot of flooring contractors don't have retention, but if you do have retention, then you should have a strategy on how to recover that money, because it's the most likely to be unpaid out of all amounts owing. So just to quickly go through a couple of clauses in a bit more detail. So a lot of contracts, especially if you get presented a subcontract, those 50-page type documents, there'll be a clause about prior works. There will be an obligation on you to check the prior works, and a failure to notify the builder of defects in the prior works may mean that you're liable for the defects, or that you cannot recover variations in relation to that. So if you've got a liability check, then you need to send someone out before you start works to check the quality of the base works. The other ones that we find for flooring contractors is care of the works. It's so hard to try to control people from damaging flooring on a construction site, especially if they're under time pressure, so then they're putting finished floors when some things are not done yet. So how are you managing the damage afterwards? And then site conditions, you just specify what you expect. What your price is based on a certain level of cleanliness, tolerance in the substrate, no moisture, those types of things. So that's all the site conditions. Rise and fall. Probably no one can, I think most subcontractors can't really negotiate rise and fall into most standard contracts. If you've got a particularly complex project, then you might want to negotiate rise and fall. Or if you've got supply of something where you can't lock in the price. But the baseline position for most contracts, unless you specifically draft it, is that there's no rise and fall. So I spoke about before with liquidated damages, and all I want to say is the misconception. Subcontractors think that if I have not delayed the builder, I cannot be hit by liquidated damages. But this is how liquidated damages really works. If you've got a date for practical completion, PC, and the date for PC is the 1st of July 2023, as soon as it goes to the 2nd of July 2023, then you're liable for liquidated damages. It's just one day, but obviously it keeps on counting. And the only way to avoid your liability for liquidated damages is to extend time by issuing an EOT. So the most common scenario we have is a client comes to us, a subcontractor says, oh, the builder's trying to hit me with LDs, but I didn't delay the project. They've calculated that I owe them $500,000 in liquidated damages, but they didn't even issue me the final drawings until a month ago. Well, actually, it's a strict liability. The subcontractor should have issued an extension of time notice. So if you're not in a position to manage the extension of time process, then you need to either delete liquidated damages or you need to cap liquidated damages. But it's certainly an obligation, a positive obligation on the subcontractor to be issuing notices. And that's the end of the presentation. So if we want to go to any questions or comments, happy to.
Awesome. Thanks, Ping. Yep, we've got a question to come in. Okay. Where a retailer is your customer and you invoice them for your service, but their customer doesn't pay them based on a dispute over the works performed, where does your business stand in relation to getting paid? Specifically where fault is only customer misconception, but refusing to pay regardless.
So in that scenario, you can still pursue payment. So I'm not sure which jurisdiction you're in.
This one, South Australia.
South Australia, did you say?
Yep.
Okay, yeah, so they've got a security, so South Australia obviously has security payments legislation. Security payments legislation in Australia and also outside Australia, the whole purpose is to prevent pay when paid provisions. So you're entitled to payment based on your contract with the client and not, sorry, with the timber flooring contractor or flooring contractor and not based on payment upstream. So even that's their problem. So you could still pursue payment just because they're not getting paid.
Fantastic. If a builder I work for goes bankrupt, what is the best way to pursue payment? So
if there is not a lot of recourse once they're in either administration or liquidation. When they're in, so generally when a builder is deemed insolvent or it considers itself that it's insolvent, they'll either put the company in voluntary administration or they'll put it directly into liquidation. When it's directly into liquidation, there's no coming back, no hope. Liquidate it and pay as much as possible to the creditors. When it's administration, there's some hope it could be recapitalized and there'll be some return to the creditors. But generally, you assume when there's an insolvency event in the construction industry, there is zero return to creditors. So what can you do? You can't do anything when it happens to you, but what can you do to prevent this? So we've talked about the terms and conditions in this session, but it's also about security. So some of you may use credit application forms. Some of you may even include personal guarantees. And there are various security that you can get against the builder. You can be a secured creditor and register your interest on the PPSR. You could get a personal guarantee from the builder. You could get property security from the builder. You can have a retention of title clause in your contract. And probably with suppliers, you'll use a retention of title clause, which basically means that you own the goods until you get paid for them. However, as soon as they're installed, you can no longer rely on that right. So if you want to do something, if you're having a lot of issues with insolvency, you can engage us to give you specific deeds or specific documents to secure your interest, and then you need to negotiate. If you don't want to negotiate at all, then you try to get forward payments. Sorry. If you don't want to get security agreements that can give you better security, the other alternative is to negotiate forward payments. So you get credit card payments, you negotiate so you have the least amount owing towards the end. But if there's a dispute and they go insolvent on the last payment claim, then you're still thinking about those security arrangements. Could I have got a personal guarantee? Could I have become a secured creditor of the company? You know, could I have had something? Does that make sense?
Yep, sure does. Next question. Hi, I want to ask a question regarding insurance builder. Back charging subcontractors for work that is done without advising the first subcontractor, which goes into part B, I think, as the builder hires another contractor to finish the job to address the issues of the job.
And I assume that the first subcontractor is being back charged for the cost of the second subcontractor?
Yes, that's correct.
Yeah. Okay, so I think insurance building, it depends on who you're dealing with. It does contain those sorts of risks. So an insurance builder will probably draft a subcontract that's not in your favor. And so you will need specific drafting to reduce the back charges. So what it's about, to avoid that kind of issue, it's about the wording in your contract in relation to what is your scope of works, what are you allowing for, what are you not allowing for, and then it's during the job, what is your communication? If they have they advised you of it? Is there have they advised you that they're going to engage another subcontractor and back charge you? So it's the credibility of what's the story there. But it still comes back to looking at the drafting in your contract and whether they are allowed to do that.
Cool. How do you manage negotiating the retention fee to a builder?
So I think it comes down to which jurisdiction you're in and what's your bargaining position on there. So we're finding that we can negotiate retention a lot more than we could in the past. There is a specific High Court judgment that came out in 2018 that said pay when paid provisions, retention clauses that are based on the builder's performance is void. So for example, the old retention clauses used to only release retention on the builder's PC and 12 months after the builder's PC. And those clauses were deemed to be void because they're not based on your performance, it's based on the builder's performance. So you after that, it became easier to negotiate and say, well, the retention that we will accept, it's got to be released on our performance. So when we finish 100% of the works, we want all the retention, and maybe even 3 months after or 6 months after, we want the rest of it. So I think what I'd say is that the more people that negotiate their contracts, negotiate retention, the easier it is for you to negotiate it. So it's everyone having a conversation about all the retention money they didn't get back. And we deal with it a lot. There's so many builders, not so many, but there are a lot of builders that have become insolvent. We have some subcontractors that are owed in outstanding retention, could be $1 million, outstanding, not retention in total, outstanding retention. And then some of them had builders go under, Lansky, Lloyd Group, all of them, and some of them lost hundreds of thousands of dollars in retention. So I think it's pushing back. And then the other thing you can do with retention is, depending on the drafting, you can register on the PPSR. So when you register on the PPSR, then it becomes you're a secured creditor. It doesn't give you any property security, but it means that you're ranked the highest out of like compared to other unsecured creditors, such as other subcontractors. So with retention, I think with negotiations, you focus on that it's the intention of retention is, I didn't mean to rhyme, but the intention is that it is security for your performance. So after you've performed your obligations, shouldn't you be entitled to the retention back?
Fantastic. So it was in New South Wales, that one. I've got lots of people.
Yeah, New South Wales has better legislation. New South Wales has retention trust accounts for some of the I can't remember which project size, but they've got retention trust accounts, and you can actually use security payments to get back the retention. So if you have outstanding retentions, you can send the details to us and we can tell you what it will cost to try to recover the retention money.
Fantastic. Got lots of people thanking you today, Ping, for your presentation and obviously making it in layman's terms so everyone can understand. So there's lots of comments coming through. Thank you for a great presentation. We got any final questions, guys, before we just finish up? Like I said, guys, Ping's obviously here to help our ATFA members. So if you do have any questions, you can always give me a call and I can pass on her details. You can call her up if you have any legal questions and she can help you. It's obviously a great part of the service of your membership. So please feel free to utilise it. So I think that's it for questions. There's a lot of people thanking you, Ping. So as well, I'd like to thank you as well for your expert legal advice and knowledge tonight. It's been a fantastic webinar. Will we receive a copy of the presentation? Ping, you happy for me to send that out to people that like it? You there? Hello?
Yes, yeah, can you hear me?
Yep, you come back. You just dropped
Yes,
out.
please send it around.
Yep, no worries, guys. If you want to email me, and I'm happy to send out the presentation for Ping, no problems at all. So, guys, there will be a recording of today's webinar put up on the ATFA website. So if you know someone who's missed it or you'd like to relive it again or get some of your staff to watch it maybe tomorrow, it should be up by midday. Also, I'd like to thank our webinar sponsor today, Burger Cedula, for their great support of our webinars. Please go to their website, www.burger-cedula.com.au. Our next webinar for the year, guys, is on the 12th of October, and the topic will be on sanding allowance, and this will be presented by ATFA trainer Mr. Peter King. This will obviously be a very popular subject and interesting topic for our members. So for all our up-and-coming events, guys, please keep a lookout on our website, our social media pages, Facebook, Instagram, and Twitter. They're all fantastic ATFA information outlets. Make sure you've got the ATFA Card Skipper app downloaded and the EMC app, pricing tool on your phone from the Google Play or App Store. Make sure you turn the notifications on, guys, because we're sending out a lot of communications through that app. So if anyone has any questions regarding ATFA or today's webinar, you can always send me an email at josh@atfa.com.au. I think that's it, guys. No more questions. So I'd like to thank you all very much for listening to today's webinar. From Ping and myself, have a great afternoon or evening, depending where you're listening from, and we look forward to talking to you all again on the 12th of October. Goodbye for now. Thanks, members.
Thanks.